Well, hi, everybody. Hey, happy Thursday to you. Bill O'Leary coming to you live. And it's where I go live every week. We call this sort of weekly series our Thirsty Thursday series. Again, where I go live, talk about a different topic that sort of strikes my interest, or maybe it's something that's come up throughout the course of the week or the past couple of weeks as part of what I do for a living. So I'm a lawyer, estate planning, wills, trust, probate, estate and trust administration. So if you're thirsting for knowledge and information and guidance, I'd like to think you've come to the right place. What I want to talk about today, this came up probably several weeks ago now, a strange family member and how to deal with them effectively in your estate plan. So look, it'd be great if everybody would get along. Then the planning for your children or grandchildren as part of your estate plan would be pretty simple, right? But unfortunately, that's not always the case. Families, of different stripes and different flavors, they can have different dynamics and maybe have conflicts for various reasons. This for sure can make the estate planning more difficult and more complicated. So here it's absolutely essential to address everything and everybody clearly and explicitly. By the way, what happens to your estate plan if you fail to take the steps before you die, on how you want to deal with estranged family members? In that situation, it is distinctly possible that your wishes will not be honored or respected. The reason why is that most states, Florida included, they have laws called the rules of intestate succession, which determine who receives your property, your assets, and so forth if you die without a will. So, if you die without a will, the state is going to have its plan is going to impose on your heirs. And so, any child that you may want to exclude from your estate might very well end up getting a share of your estate, an outcome that you don't want. If you fail to make it clear that this particular person, family member, is not to inherit from your estate. If you don't make that clear, they may still be able to come in and make a claim against assets of your estate. Fortunately, though, you can avoid these problems by taking action now and setting forth your wishes in writing in a clear and unmistakable way. So, how do you make your intentions clear and in writing? Start by writing up a will, last will and testament. So, in the will, you can state very clearly that you are specifically not providing for any of your estate to go to an excluded child, grandchild, as an example. And although, yeah, that does sound harsh, you have to state your wishes explicitly and clearly to avoid legal battles in the future where maybe the omitted family member comes in and makes a claim against the estate for what they think is their rightful share. Now, be aware, though, that disinheriting a child who maybe is confused or angry about being excluded, disinherited, could result in that child contesting the will. So, is there a better solution than just having a will and that possibility of a will challenge, a will contest? Yes, there is. And that is by putting in place what's called a living trust. You see, a living trust does the same thing that a will does in this sense. They both are ways to state clearly in writing your answers to four very important questions. Number one, who gets your stuff? Number two, what they get. Three, when they get it. And four, how they get it. Okay, so if a will answers those questions and a trust answers the same four questions, when would you do one over the other? Well, if all you have is a will, an excluded heir can come in and challenge the will because the very first thing that's done after death is that the will is filed with the courts. It's public record. Anybody to read online these days, including the disinherited heir. A trust, by contrast, is a much better way to answer those questions. Number one, a living trust allows everything to go to your loved ones smoothly, quickly, and easily by avoiding the probate court, which a will may not. But secondly, there's another very important sort of benefit of having a living trust when you are excluding a natural heir, okay, like a child. Because again, if all you have is a will to answer those four questions, that excluded child can go ahead and make a claim against the estate. Um, with a living trust, That is not filed with the court records like a will is, you see. So it's a private, and so the excluded child or grandchild that's removed from your estate will never see the trust. It's private. It's not public record. So obviously, these are often difficult questions to navigate: getting a will or a trust, or or the decision whether to disinherit a natural heir like a child or grandchild. Tough questions to deal with. That's why you need an experienced estate planning lawyer to help guide you so you can state clearly in writing what you want in order to reduce the chances of a legal dispute. One last thing, and some people have read this on the internet, what's called a no contest clause. Hey, I could solve the problem by putting in sort of verbiage in my, let's say, will or trust that says, hey, if a beneficiary who's excluded ever challenges it, they forfeit their inheritance. This is called a no contest clause. It's also known as an interim clause, Latin term. Unfortunately, this kind of legal clause is not enforceable in Florida. So all the more important to talk with an experienced estate and trust lawyer. If you'd like to know a little bit more about how to deal with an estranged family member as part of your estate plan and maybe how we can help, well, we would be delighted to talk to you. So we invite you to schedule a free 15-minute discovery phone call. Going to our website, Legacy Planning Law Group, click on the book your free call. It's sort of gold in color. Takes you to our booking calendar. Pick the day and time that works for you. We can start the conversation. Hey, by the way, if you've enjoyed this video, do like and share and subscribe. Subscribe to our YouTube channel, Legacy Planning Law Group. We're getting tremendous feedback on the content that we have, and keep putting up new content all the time. So I'm going to give, as part of this Thirsty Thursday series, another talk next Thursday about the same time. So if you're thirsting for knowledge, we will quench your thirst. So Bill O'Leary, I'm going to sign off for now and encourage you, go make it a great day. And if you can, even in a small way, make it a better world.